He'll be pleading to count 3 and receive a sentence of 3 years. Tennessee Department of Corrections as a range 1 offender at a statutory 100% release eligibility. Sentence is suspended to 3 years supervised probation, no contact with Capser Hall, Michael Harden, or Chandler Thompson, 20 hours of public service work. He must also complete anger management course, and he's not allowed at Hustle Recovery or their property. No contact with the residents of Hustle Recovery, and he'll be ordered to pay the court costs. Mr. Williams, raise your right hand. Let's place you under oath.
I do.
Thank you. You can put your hand down. State your full name for the record.
Billy Michael Williams.
Mr. Williams, you heard me say what the agreement is, but have you seen or been shown a copy of the charges against you and gone over them with Mr. Lockhart? And you and he discussed the range of punishments you're facing as well as any possible defenses you might have?
Yes.
Well, it's indicated that you want to enter a plea of guilty to this charge according to this agreement. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes.
Do you understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own?
I do.
Do you understand that at trial you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
I do.
Do you understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
I do.
Do you understand that at trial you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
I do.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
I do.
Do you understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
I do.
Do you understand everything I've explained to you?
I do.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
Do you understand if you plead guilty, the court of the state could ask you questions about these offenses or this offense, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine you are lying under oath?
I do.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, sir.
Do you understand? All right, then I will ask you this. Are you guilty of the charge that you're pleading guilty? Are you guilty of this aggravated assault charge?
Yes, sir.
Tell me what happened.
I knocked over the trash cans and I went back to go pick them up, and they all ran out on me, and it led to an argument.
Led to an argument. All right, let's have the state supplement those facts.
Case number 19795 were individuals from Hustle Recovery are outside.
And this is on video.
This is on
Right.
where he was screaming profusely at them and waving his gun around. He did not prepare the weapon and then interrupted. This did happen in Cheatham County. He's pleading.
All right, Mr. Williams, are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Lockhart's done a good job of representing you competently?
I do.
Mr. Lockhart, do you know of any reason you should not enter this plea?
I do not, Your Honor.
Then Billy Williams and docket number 19795, upon your plea of guilty to count 3 of the indictment, I find you guilty, sentence you to 3 years in Tennessee Department of Corrections. That will be suspended to supervised probation. That is as a 100% release eligibility if you were to have to serve that sentence. You're to have no contact with Capser Hall, Michael Harden, Chandler Thompson. Or to perform 20 hours of public service work and complete an anger management course. You are not allowed to have any contact with Hustle Recovery or their property or the residents of Hustle Recovery. You're also ordered to pay the court costs. He needs to see the probation department.
Thank you, Your Honor.
You said you had your other client. Now, Mr. Lockhart.
Yes, Your Honor, Mr. Wolfe.
All right, Mr. Northcutt. What are we doing on Mr. Northcutt?
Your Honor, he's going to be entering a plea to aggravated stalking. He'll receive General. You've got the judgment?
I do.
All right. There are several conditions that Your Honor will need to go through with him as a condition of this probation in regard to email and social media.
All right, I've been handed a judgment form that will sign after the entry of this plea, and this does contain specific conditions. He is going to be entering to a plea to a felony charge of is it especially aggravated
Aggravated.
stalking.
Yes, Your Honor.
And sentence of 3 years suspended to probation. But there are additional charges, and you need to make sure you understand this. Number one, you are going to be serving the sentence outside of the range. You are to have no contact with Chelsea Barnes. You shall refrain from making any social media posts about Chelsea Barnes. You shall report to your probation officer in person. You're to wear a GPS ankle monitor for 1 year or the sentence. If there are no violations, the defendant must disclose all email and social media account information to the state's probation. He will be subject to having those accounts checked by state's probation. Now, the ankle monitor is for 1 year.
For 1 year, Your Honor, he's been wearing it so far. The big concerns in this particular case is a lot of social media posts. If the monitor is not, he hasn't had any violations, I can see that it can come off as it's not the main concern.
After 1 year, if no violations, it can be removed.
Yes, Your Honor.
All right, Mr. Northcutt, raise your right hand. Let's place you under oath.
Yes, ma'am.
Thank you. Step up to that microphone. State your full name for the record.
Aaron Patrick Northcutt.
Mr. Northcutt, you are here today based on an indictment charging you with especially aggravated stalking, but you are pleading to aggravated stalking, a lesser charge. And you've heard that your sentence will be 3 years, which is outside the range. But do you understand what you're charged with? And you've seen or been shown a copy of those charges and talked them over with Mr. Locker, then you and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to this charge. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand if we had that trial, you would have the right to have a lawyer, and if you could not afford your own, we would appoint one for you?
Yes, sir.
Do you understand if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out
Yes, sir.
with the state. Do you understand those conditions are going to apply to your sentence? Do you understand that?
Yes, sir.
And do you understand this is going to result in a conviction, a felony conviction that will be on your record in the future to make more severe the punishment you receive if you were ever again convicted of a crime?
Good. Yeah.
Do you understand everything I've explained to you? Can I answer yes or no?
Yes.
Do you want to plead guilty according to this agreement to waive your right to a trial and to an appeal?
Yeah.
If you plead guilty today, do you understand the state or the court could ask you questions about this offense? And if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine you are lying under oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
Yeah.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty?
Yes.
Then are you guilty of this stalking charge?
Yes.
Do you want to lay the foundation, General?
Your Honor, on June 29th, Officer Tiffany Renendez responded to Kingston Springs and respond to a report of stalking. She spoke to Chelsea Barnes. Chelsea Barnes let her know that in between June 25th and June 27th and June 29th, that there had been multiple social media posts by Mr. Northcutt
referencing Miss Barnes, referencing the order of protection that had previously been granted, also making comments and referencing her by her initials of CB on the internet and through social media. He does have a prior conviction of stalking, and that would be the basis for the plea, Your Honor.
All right, Mr. Northcutt, do you understand that's what the state's evidence would be if you went to trial?
Yes, sir.
Are you satisfied with your attorney's services?
I guess.
You guess?
Yeah.
Now, you have the right to say, no, I'm not happy with this, and you can go
I
to
mean, I'm
trial.
not happy about a felony.
I
No.
understand. That would be something that you might have thought through before you began engaging in the conduct. I'll just say that. But what I'm asking you is that do you have some problem with your lawyer services in this case?
No.
Mr. Locker, do you know of any reason he should not enter this plea?
I didn't. If he thinks this is not a good deal, I'd be happy to set this.
Mr. Northcutt, I don't care whether you enter this plea or not. If you don't enter this plea, you're going back to the original charge of especially aggravated stalking. And we will set you a trial date and give you a speedy trial as we can. But I need you to understand that I'm not going to have a situation entered where you come back later and say, well, I wasn't really happy with my lawyer services. I don't think he did a good job. And so, but I went ahead and took the plea because the judge forced me to do it. I don't care. If you don't want to do this, then we'll go back to the original especially aggravated charge. You've been through this before. The state has laid out what their evidence would be at trial. So you might have an idea of whether or not you're looking at being convicted or not. So you want to step aside and talk this over with your lawyer to make sure about this?
It's okay.
There are a lot of times people find themselves in a position of their own making that they don't like any of the results of what happens. There's no good way out, so to speak. And sometimes you have to make the best of a bad situation. I'm going to take it that that's what you feel like you're in. You're trying to make the best of a bad situation. But I need you to stay on the record that you're satisfied that your lawyer has done a good job of representing you.
Yes.
So do you state that?
Yes.
Mr. Lockett, now do you have any problems with you've made it clear to him that he can withdraw this plea and go to trial?
I think it's in his best interest. The proof is overwhelming. They have copies of the social media post. He does have a previous conviction.
I understand, Mr. North. I'm sorry for cutting you off. I understand Mr. Northcutt is not happy about having a felony conviction. The problem is that this course of conduct that landed you here in this courtroom is why you have a felony. The statutes are what they are. A lot of times people commit crimes and only to find out, gosh, that's a lot more severe than I thought it was going to be. So it's a lesson learned. All right. Anything further from the state?
No, Your Honor.
Then Aaron P. Northcutt and docket number 19808, upon your plea of guilty to aggravated stalking, I find you guilty, sentence you to 3 years Tennessee Department of Corrections. You will be suspended to serve that on probation. However, there are additional conditions. You have agreed to serve this sentence outside of the range. You shall have no contact with Chelsea Barnes, and you shall make no social media posts about Chelsea Barnes. And that means you shall not post them under your name. You shall not post them under some assumed name. So you can't catfish or whatever that term is and try to come in under some other assumed name and make comments. You'll report to your state probation officer in person. You'll wear that GPS ankle monitor for at least 1 year. And if there's no violations, you can see about having that removed. But you'll have to have an order submitted to the judge to remove it. You'll disclose all of your email and social media account information to your probation officer, and you're subject to having those accounts checked by state probation. Now, I understand you're not happy about this felony plea, but I want to make it clear to you, you've now been found guilty and sentenced to probation. It will, there's an old, John Milton was a famous English writer, and he wrote Paradise Lost. You probably have never heard of that, but it was a famous book, and he likens the person being dangled over the bowels of hell by a string. And that's, for some reason, stuck with me all my years. You're dangling over the State Department of Corrections by a single string that I'm holding the end to. And if you violate your probation by making some report or contacting this young woman again, I'm going to let that string go, and you're going to go to prison for 3 years, plus any additional charges. You understand that? Well, I hope you've learned your lesson, but somehow questioned that, but anyway, you see your probation officer.
Thank you, Your Honor.